Two Pierce County parents are being held on a $1 million bail tonight, accused of murdering their infant son, who was just 7 weeks old. The couple appeared in court today after their baby died in the hospital. Doctors say the boy suffered.
A 7-week-old baby boy dies after spending 5 days in the hospital fighting for his life. 3 days after he passed, his mother and his father were behind bars, charged with his murder. This case is still unfolding. There are questions that don't yet have answers, legal processes that are just getting started, and a full pathology report that isn't even back yet. But what we know right now, from the probable cause affidavit, from the police interviews, from the arraignment hearings, is already shocking enough to stop you cold. And the details that keep surfacing as this investigation continues are getting harder and harder to process. This is playing out in Pierce County, Washington, and it starts on March 5, 2026, when officers from the Lakewood Police Department responded to Mary Bridge Children's Hospital after a call came in regarding a child abuse incident. When officers arrived, a social worker met them and reported that a 7-week-old infant boy had been transported to that hospital the day before, March 4th, by West Pierce Fire and Rescue, following a life-threatening emergency. The social worker told police the infant, identified in all records only as NC, had been admitted and that he was not expected to survive. His parents, 21-year-old Mark Anthony Clammer and 19-year-old Alyssa Vanderbeck, were not at the hospital when police arrived. They had left. When Clammer and Vanderbeck eventually came back to the hospital, officers were waiting, and the officer who made contact with them noted something immediately. Their demeanor was unusual, not what you would expect from two young parents whose newborn was in a room down the hall in critical condition, not expected to live. That observation went into the report, and it would be one of many small details that, stacked together, began to build a deeply troubling picture for investigators. The parents were separated. Each was interviewed privately and individually, and what each of them said, independently to different officers, became the foundation of this entire case. So let's walk through it, because the timeline matters, every single minute of it. According to the probable cause affidavit, here is what Mark Clammer, the father, told investigators. He said he fed the baby approximately 4 ounces of formula from a bottle. Then, about 2 hours later, he gave him 1 more ounce. During that second feeding, NC became fussy, and Clammer said that when the baby was fussy, he picked him up, and here is where he demonstrated for police exactly what he did next. He made a forward and backward jerking motion with his body. He said he watched his son's head snap back hard before he tried to catch it and pull the baby into his chest. Think about that for a second. A 7-week-old, his head snapping back hard, in the hands of a man who would later tell police he knew in that moment that what he had done was rough. And when investigators asked Clammer what NC looked like immediately after that, after his head had jerked back, after his father had pulled him to his chest, Clammer replied, and I'm reading directly from the affidavit, "He looked normal. I mean, he wasn't crying. I thought he was just getting tired." He thought he was getting tired. Sometime between 1 and 1:15 in the afternoon, Vanderbeck woke up. She and Clammer took a shower together, with NC in his bouncer seat in the bathroom with them. When they stepped out of that shower, according to both of their accounts, is when things went from deeply concerning to catastrophic. This is the part of this story that is the hardest to sit with, because what happens next is not one mistake in a moment of blind panic, it is a full hour of decisions. When Vanderbeck got out of the shower, she saw it immediately. NC was breathing abnormally. His eye movements were wrong, and they were progressively getting worse, not better. At some point, she forced his eyes open, trying to get a response from him. She and Clammer physically shook the baby, panicking, trying to rouse him. When police later asked Vanderbeck whether shaking him at that point could have made his condition worse, she said, and I'm quoting directly, "Like he could have had minor shaken baby, and then it got worse. We were so scared." I want to pause here for a moment, because from her perspective, she's 19 years old. One minute she's in the shower, and the next minute her newborn is limp and unresponsive in front of her. The terror of that moment must have been overwhelming. I don't think anyone listening to this would dispute that. But here is what happened next. And this is where the story takes a turn that investigators say tells them something critical about what was happening in that home. Vanderbeck started filming. Not calling 911, not running towards the nearest emergency room. Filming. She took multiple videos of NC in multiple locations inside the residence, and then she started texting and reaching out to friends and family, sending those videos, asking people what they thought might be wrong. She wondered if maybe NC had had a seizure. She described him as distraught, eyes open but completely unresponsive. Police later recovered those videos, and what is in them is extremely difficult to hear described. The baby can be seen with labored breathing, posturing, grunting, the kind of breathing pattern that, according to law enforcement, is a direct indicator that something is catastrophically wrong. In one video, NC has one eye partially open and the other partially closed, and at one point in those recordings, the baby appears to stop breathing entirely. And still, no one called 911. Meanwhile, Claimer had his own theory about what was wrong with his son. He thought it might be gas. He spent approximately 10 minutes trying to burp the baby. He later told police that his intuition about NC was usually good, that often when Vanderbeck thought something might be wrong, he would tell her the baby was fine, and he would turn out to be right. This time, he said, felt different. When things still didn't improve, Claimer called a triage nurse. The automated phone system put him on hold. That call lasted about 11 minutes total. He dialed 911 as soon as it ended. But here is what investigators determined after going through all of Vanderbeck's text messages, the video timestamps, and both parents' accounts side by side. Approximately 1 hour passed between when NC first showed signs of severe distress and when 911 was actually called. 1 full hour. A baby who appeared on video to stop breathing, and 60 minutes went by before a single call went out to emergency services. Instead, there were videos, texts, a 10-minute attempt to burp him, 11 minutes on hold with a triage line. That timeline is not a coincidence in the affidavit. That timeline is the case. I need to warn you, what comes next is very hard to hear, but it is important. When the physicians at Mary Bridge Children's Hospital examined NC, here is what they documented on a 7-week-old child. Subdural hemorrhages, bleeding between the brain and skull. Anoxic brain injury, brain damage caused by a lack of oxygen. Extensive retinal hemorrhages, severe bleeding in both eyes. And what appeared to be healing rib fractures, specifically of the posterior medial 8th and 9th ribs identified on CT imaging. Healing rib fractures. That word, healing, is one of the most significant details in this entire case, because healing fractures don't come from March 4th. They were already in the process of mending before that day, which means this child had been injured before, and no one reported it. No one sought medical attention for it. Those bones were quietly knitting themselves back together inside a 7-week-old baby who had no way to tell anyone he was hurting. The physician's full assessment concluded that given the nature of these injuries, their pattern, and the complete absence of any reported accidental trauma, the findings were consistent with an acceleration-deceleration injury with a rotational component. The clinical conclusion? Abusive head trauma. NC spent 5 days fighting. He died on March 9, 2026. The medical examiner conducted an autopsy on March 10th and 11th. Additional findings included intracranial and spinal hemorrhaging and what appeared to be fractures of the 5th and 6th ribs. The tentative cause of death, pending full pathology results from the Pierce County Medical Examiner's Office. Homicide, due to abusive head trauma. Now I need to take you back to March 8th, the day before NC died, while he was still alive in that hospital room. Investigators located a video that Vanderbeck posted publicly to TikTok on that date. She is in the bathroom of her baby's hospital room, dancing slowly, upbeat music playing in the background. her dying son was feet away. That video has since been taken down, but investigators documented it in the affidavit, and it has become one of the most talked about pieces of this entire case. Legal experts who have reviewed the details note that prosecutors will almost certainly fight to get that video in front of a jury. Not because it proves what happened on March 4th, it doesn't, but because of what it suggests about the state of mind of this mother in the days that followed. Defense attorneys will push back hard, arguing that grief looks different on different people, and that a judge will have to decide whether the video's emotional impact on a jury outweighs its actual legal value. That battle will happen before trial even begins. On March 9, 2026, the same day his son passed away, Mark Clammer was arrested. Alyssa Vanderbeck was arrested 2 days later, on March 11th, following the completion of the autopsy. On Thursday, March 12th, both appeared in Pierce County Superior Court for their arraignments. For Vanderbeck, prosecutors requested bail of $1 million, arguing she poses a significant flight risk. She is unemployed, has limited family support, and while she was in custody, investigators noted that she called Clammer from jail, asking him to pay rent and discussing the possibility of staying at an Airbnb. The prosecution's position was clear. This is not the behavior of someone planning to show up and face the consequences. Her charge? 1 count of murder in the second degree, with the domestic violence special allegation and an aggravating factor, the vulnerable victim, in this case, a 7-week-old newborn. The judge agreed, bail set at $1 million, and it stands today. For Clammer, prosecutors made the same bail request, $1 million, citing the same risk factors: unemployed, limited support, serious charges with serious evidence behind them. His charges, 2 counts of murder in the second degree, with the same domestic violence special allegation and the same aggravating circumstance of a vulnerable victim. Same bail, $1 million. And then the prosecutor said something that made clear this may not be the final word on what either of them is facing. Because of those healing rib fractures, because of what they suggest about what was happening in that home before March 4th, the charge of homicide by abuse remains potentially on the table. That determination depends on the full pathology report, which has not yet come back from the Pierce County Medical Examiner's Office. Under Washington state law, a conviction on second-degree murder carries a maximum sentence of life in prison. Both defendants are due back in court on April 8th for a pre-trial hearing. Now I want to walk you through what legal experts say is likely to happen from here, because this case is going to be complex in ways that go well beyond what the affidavit already tells us. The foundation of the prosecution's case, according to legal analysis, has to be a strong medical expert. Not just a doctor who can explain what the injuries are, but someone who can teach a jury what caused them, when they were caused, and why there is no accidental explanation for what happened to this child. A forensic pediatrician who specializes in child abuse cases can look at imaging and give a jury a window of time in which those rib fractures occurred. They can speak to the forces required to fracture an infant's ribs. They can explain why those injuries are consistent with a pattern of repeated trauma over time, rather than a single, isolated event. That testimony is the backbone of everything else prosecutors want to build. And what they are building goes beyond March 4th. The healing rib fractures documented in the physician's initial assessment, combined with the additional rib fractures found during the autopsy, tell a story of a child who was being hurt before the day that 911 was finally called. Proving who was responsible for those older injuries and when they happened is one of the most significant legal challenges prosecutors will face as this case moves toward trial. The most effective path to answering that question, according to legal experts who have examined cases like this one, is almost always the same: get one of the defendants to testify against the other. And here is something many people don't realize about how that works. Marital privilege, the legal protection that prevents spouses from being forced to testify against one another, only applies to words spoken in private. It does not apply to things one spouse witnessed the other doing. If Vanderbeck saw Clammer harm their son, she can be called to testify about that. If Clammer witnessed something Vanderbeck did, the same applies. The privilege does not cover actions, only private words. Which means the cleanest path to conviction on the most serious charges runs directly through whichever parent decides or is persuaded to cooperate first. That decision, which parent to offer a deal to and on what terms, is one of the most consequential choices prosecutors will make in the weeks ahead. Traditional legal strategy says you offer the deal to the person who is less culpable in the underlying crime. Based on what we know right now, that points toward Vanderbeck. Clammer is the one who, by his own account and by her account, performed the jerking motion that snapped NC's head back. Vanderbeck's physical contact with the baby after that point, according to her own statement, came from panic, not from intent. But the tick-tock complicates that calculation significantly. A key part of what makes a cooperating witness valuable to a prosecution is their credibility in front of a jury, and a 19-year-old woman who posted a dancing video to social media from the bathroom of her dying infant's hospital room is going to face a devastating cross-examination if she takes that witness stand. Defense attorneys for Clammer would use that video to undermine everything she says, so prosecutors have to weigh what they gain from her cooperation against how a jury is going to receive her, and that is not a simple equation. There is also the question of what both defendants' social media and financial situations reveal about the environment NC was living in. Clammer, when interviewed by police, was described as emotional, tearful, and visibly exhausted. He spoke at length about financial pressure, housing instability, and unemployment. He said multiple times that he believed in God and that he was terrified for his son. Vanderbeck's own posts tell a similar story from a different angle. In January, the same month NC was born, she wrote publicly that she hated feeling like the worst mother in existence. And on March 3rd, one day before the 911 call, she posted about how hard it was going to be to find childcare so she and Clammer could both return to work. Defense attorneys will take all of that and construct a portrait of two overwhelmed young people who were never equipped for the reality of what they were facing, and argue that what happened to NC was a tragedy born of exhaustion and fear, not malice. It is a strategy known as jury nullification, where the defense is not disputing the facts so much as asking the jury to feel enough sympathy for the defendants that they cannot bring themselves to vote for conviction. Legal experts are clear that this can work, it only requires one juror, and defense attorneys will screen candidates carefully during selection, looking specifically for people who might be reached by that argument. Prosecutors, meanwhile, will ask the jury a different question. They will point to those healing rib fractures and ask, does exhaustion explain broken bones on a newborn that no one ever reported? They will point to the hour that passed before 911 was called and ask, does panic explain 60 minutes of videos and texts instead of a single phone call? They will point to the tick-tock and ask, does grief look like this? And they will argue that the answer to all three questions is no, and that the evidence taken together points not to tragedy, but to something far more deliberate and far more serious. Defense attorneys have increasingly turned to another strategy as well, challenging the underlying science of shaken baby syndrome itself. Over the past decade, a well-organized network of expert witnesses has emerged who are specifically available to testify that the medical community's understanding of how shaking kills infants is not as settled as prosecutors present it to be. These experts attack the causation element of the charge, arguing that you cannot definitively prove from the injuries alone what caused an infant's death or who caused it. They suggest alternative explanations, they plant seeds of doubt, and legal experts note that you do not need to convince an entire jury with those arguments, you only need to convince one person. One juror who is uncertain about the causation evidence means a hung jury. A hung jury means starting over. This is why the medical expert on the prosecution side carries so much weight. The goal is not just to explain what happened, it is to explain it in a way that leaves no room for the defense's counter-narrative to take hold, to make the science so clear, so accessible, and so human that even a juror who has heard the defense's expert cannot walk away uncertain about what killed this child and why. April 8th, 2026. That is the next date on both court dockets. a pretrial hearing for both Claimer and Vanderbeck in Pierce County Superior Court. Between now and then, the full pathology report is expected back from the Pierce County Medical Examiner's Office. That report could change the shape of the charges dramatically. If the findings confirm what investigators already suspect, that the injuries to this child were sustained over a period of time and not in a single incident, then the charge of homicide by abuse becomes not just a possibility, but a very real probability. And that is a more serious charge, with even more serious consequences than what either defendant is currently facing. Both Claimer and Vanderbeck remain in custody. Both are held on $1 million bail, and both are looking at a future that, if prosecutors have their way, will be measured not in months, but in decades. A 7-week-old baby came into this world and had 7 weeks to experience it. 7 weeks. His name is being kept out of this coverage, but he was real. He existed. And whatever happens in that courtroom on April 8th and every date that follows, his story is now part of the permanent record. We are going to follow every development in this case, the pathology report, the pretrial hearings, the charging decisions, and ultimately what a Pierce County jury decides. If you want to stay with us on this story, subscribe right now and hit the bell. We are also on Spotify, and we are now streaming on Peacock. Let me go deeper on a few things here, because I think this case deserves more than a surface-level look at the charges. Start with the medical evidence, because that is where this case is either won or lost for prosecutors. What the physicians at Marybridge documented is not a list of injuries you arrive at through a fall, or a trip, or an accident with a piece of furniture. Subdural hemorrhages, retinal hemorrhages, anoxic brain damage, and now from the autopsy, intracranial and spinal hemorrhaging alongside what appear to be 2 additional rib fractures, the 5th and 6th, on top of the 8th and 9th that were already identified on imaging. That is not one event. That is not even 2 events. That is a pattern of repeated trauma to a child who weighed, at 7 weeks old, probably somewhere between 8 and 12 pounds. A child whose bones are still soft, whose skull plates have not yet fully fused, whose brain literally floats inside its casing and moves with every jerk and shake of the head. The force required to produce this kind of injury in an infant this small is not something that happens accidentally. It is not something that happens from a rough burp or a startled grab. Experts in forensic pediatrics are very clear on this point, and the prosecution's entire structural argument depends on finding the right expert to stand in that courtroom and translate that science into language that 12 ordinary people can hold on to and believe, and cannot be talked out of by whoever the defense puts on the stand. Because make no mistake, the defense will have their own expert. They almost certainly already have someone in mind. Over the last 15 years, a movement has taken root inside criminal defense circles specifically aimed at dismantling the science of shaken baby syndrome in courtrooms. Defense attorneys attend seminars on how to challenge this evidence. They share lists of expert witnesses who are available to testify that the medical consensus around infant head trauma is less settled than prosecutors claim. These experts are well paid and well practiced, and their entire job in a trial like this one is to create enough uncertainty around a single element, typically causation, that at least one juror walks into that deliberation room unsure. One juror. That is all it takes for a hung jury. And a hung jury sends everyone back to square one. This is why prosecutors in infant abuse cases do not simply rely on the medical evidence being obvious. They over-prepare the medical expert. They rehearse the testimony. They anticipate every angle the defense will push from, and they make sure their doctor can handle cross-examination without giving ground on the things that matter most. The science is sound, but sound science still has to survive a courtroom. Beyond the medical argument, there is the matter of what the delay in calling 911 means legally, and I want to be specific about this, because it is easy to look at that hour and feel outrage without fully understanding why it matters as a matter of law. In order to convict someone of the most serious crimes, the kind of charges that carry life sentences, prosecutors have to prove not just that the defendant did something, but that they did it with a specific mental state. The legal term is mens rea, which translates roughly as guilty mind. The question is not just what happened. The question is what was going on inside these two people when it was happening. Were they reckless? Were they criminally negligent? Did they act with a depraved indifference to human life? The 1-hour gap is evidence that speaks directly to that question. Because here is the reality of what calling 911 means. Calling 911 means paramedics come. It also means very possibly that police come, and police ask questions. They look around, they look at the baby, they start an investigation. And if you have done something to that baby that you don't want anyone to find out about, or if you're afraid that what happened is going to look a certain way when someone starts asking questions, then calling 911 is the last thing you want to do.
Taking videos instead, texting friends, calling a triage nurse through an automated phone tree, spending 10 minutes trying to burp a baby who has stopped breathing on camera. Prosecutors will argue that each of those choices, made one after another over 60 minutes, is evidence of a conscious decision to avoid bringing law enforcement into that apartment. And that conscious decision, that awareness of guilt, is precisely what they need to establish the mental state required for the most serious charges. It is, as legal experts have noted in reviewing this case, arguably more powerful evidence of that mental state than the TikTok video. The TikTok is emotionally explosive. A jury seeing a mother dancing in the bathroom while her dying son lies in the next room is going to feel something visceral and immediate. But the defense can argue, and will argue, that grief is unpredictable, that people in shock do inexplicable things, that it tells you nothing about what she knew or intended on March 4th. The hour-long delay does not have that escape hatch. The hour-long delay has timestamps, it has text messages, it has videos with metadata. It is a documented, sequential record of 60 minutes during which a baby was dying and no call was made. That is the evidence that, according to legal experts, forms the strongest foundation for the prosecution's argument about what these two people knew and chose. There is one more thread in this case that deserves attention, and it is the question of what happens between now and trial with these two defendants' relationship to each other. They are not strangers. They are not former business partners or acquaintances who happened to be at the same place when something went wrong. They are co-parents. They lived together. They had a child together. They have almost certainly told each other things about what happened on March 4th, about what happened before March 4th, that no one else on earth knows. And now they are sitting in separate jail cells, represented by separate attorneys, with legal interests that are directly opposed to one another. The prosecutor cannot talk to either of them directly. That is not how it works. The conversation goes through lawyers, and the lawyer for each defendant wants the best possible outcome for their individual client, which means each of them has an interest in what information the other one holds and what it might be worth to a prosecutor. The offer that gets made in a situation like this is essentially, your client has a window. They are young. They do not want to spend the next 30 years in a cell. But that window requires something in return: cooperation, information, and the willingness to testify under oath about what they know. The deal goes to the person whose testimony is most valuable and whose culpability is most defensible. And in this case, that calculation is genuinely complicated by the TikTok, by the relative severity of what each person is alleged to have done, and by whatever the full pathology report reveals when it comes back. What we know for certain is that neither of these defendants is in a position of strength. The evidence in the affidavit is substantial, the medical findings are severe, the timeline is documented, and the pathology report has not yet arrived. Whatever it contains could change the trajectory of this entire case, and not in a direction that is favorable to either Mark Clammer or Alyssa Vanderbeck. April 8th is the next court date, the pre-trial hearing. That is where this case takes its next public step, and we will be there to walk you through every development as it happens. Because a 7-week-old boy is gone, and the process of answering for that, however long it takes, however complicated the legal path becomes, is just getting started. Before I let you go, I want to step back for just a moment and talk about something that does not fit neatly into any legal category, and that is the human context of this case, because I think it matters for how we process what we are hearing. Mark Clammer was 21 years old when his son was born. Alyssa Vanderbeck was 18. By the time NC died, she had just turned 19. These are not middle-aged people with established lives and resources and support systems. These are teenagers and early 20-somethings who brought a baby into a home marked by financial stress, unemployment, housing instability, and, by Alyssa Vanderbeck's own public admission, deep uncertainty about whether she was doing any of it right. Her January post, saying she felt like the worst mother in existence, was written in the same month her son was born. That is not a statement made months into parenthood after a long struggle. That is a feeling she was carrying from the very beginning. None of that is a defense. I want to be absolutely clear about that. None of it explains what those healing rib fractures mean. None of it explains the hour before 911. None of it changes what the medical examiner found or what the physicians documented. But it does tell us something about the conditions under which this child came into the world, and about the gap between what this baby needed and what was available to him from the moment he was born. That is not a gap that the legal system is equipped to address retroactively. The legal system's job now is to determine what happened, who is responsible, and what the consequences should be. And on all three of those questions, the evidence that has already emerged from this investigation is substantial and serious and still growing. The pathology report will tell us more. The pretrial hearing on April 8th will tell us more. The charging decisions that follow will tell us more. And at the end of it all, however long that takes, a jury in Pierce County, Washington will tell us what they believe beyond a reasonable doubt. We will be here for every step of it. Every hearing, every filing, every development. If you want to follow this case with us, subscribe right now and make sure you have notifications turned on.